The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our first case is Button versus Level 4 Orthotics and Prosthesis, Inc. et al. And we will hear from the appellant. I understand that there's, y'all will tell us what your target times may be, but we will allow counsel to keep up with their own time.
Thank you. Thank you, Mr. Chief Justice. May it please the court, and in view of the cross appeal, I intend to reserve 15 minutes of my time to address both the cross appeal and for rebuttal, and understanding the admonition that we keep track of our own time. My name is Brian Church, and I'm with the law firm of Robinson Bradshaw, which represents the appellants Seth Ellis and Level 4 Holdings in this appeal, as well as the named defendants to the cross appeal. Mr. Ellis and Level 4 Holdings request that this court reverse the business court's denial of their Rule 12b2 motion to dismiss for lack of personal jurisdiction. At issue in their appeal are the ordered expectations of persons, both businesses and individuals, that invest in entities that operate in North Carolina, as well as the individuals who work for those investors. Personal jurisdiction rules help create predictability for businesses and investors, those out-of-state businesses and investors, regarding where they may be subject to legal action. Those rules provide protection and fairness to the individuals who work for those businesses. And the results of the business court's denial of the motions to dismiss in this case disrupt those ordered expectations and unfairly subject out-of-state litigants to personal jurisdiction here in North Carolina. The plaintiff, Mr. Button, is the former CEO of Level 4 Inc., which is a medical prosthetic device maker that operates in Forsyth County. Level 4 Holdings, as the name implies, is the holding company that owns Level 4 Inc. It is incorporated in and operates out of Florida. Seth Ellis was a member of the investment committee of Penta Fund, which is a fund that invested in, among other things, Level 4 Holdings. Mr. Ellis lives and works in Florida. Mr. Button is a New Jersey resident who worked principally in New Jersey. Mr. Button sued Mr. Ellis for tortious interference with contract and for civil conspiracy arising out of Mr. Ellis's alleged agreement to aid in the breach of his employment agreement. Nowhere does the complaint nor the supporting affidavit describe where Mr. Ellis made the agreement or what overt acts he did in furtherance of this agreement, or what contacts Mr. Ellis supposedly had in North Carolina when he was supposedly tortiously interfering with the employment agreement or otherwise conspiring. So I will first, and as the briefs address, the first issue here is the long arm statute. At the threshold of each question of personal jurisdiction, there is a statutory question. Does the North Carolina law authorize the exercise of personal jurisdiction? The business court dispensed with the question entirely. So we do not know how the business court analyzed the question. It essentially said that the analysis collapses into a single inquiry, minimum contacts. But nevertheless, there is still a statute, the long arm statute, and having had the business court analyze that statute, it would have seen the weakness in the case for personal jurisdiction here. Mr. Button proffers some arguments in favor of the long arm statute in his brief. First, he says that the long arm statute applies because Mr. Button suffered injury in North Carolina, because this is the state in which he was transiently present when he learned of his termination. He cites no precedent for this proposition. Again, Mr. Button lived and worked principally in New Jersey. If he suffered a financial harm, it was in New Jersey where he lived and where he was receiving his funds. Mr. Button says alternatively that Mr. Ellis had substantial contacts with North Carolina. He offers absolutely no factual attribution for this assertion, and there is none in the record for that. That's it. That's all we have.
So let's go back to your characterization of the business court's order. The business court, as you've indicated, references two steps, and then it has a quote from one of its cases citing one of our cases, as well as a Court of Appeals case. It says, North Carolina's long-arm statute has been interpreted to allow the exercise of personal jurisdiction to the fullest extent allowed under the Due Process Clause. The two-step analysis collapses into one. Is the business court right or wrong in making that observation?
That observation is correct insofar as the text of the statute authorizes the exercise of jurisdiction.
So really we're talking about fundamental fairness here, right?
That it certainly is an essential question, fundamental fairness. But in reviewing what the long-arm statute says, it certainly points up the issues of fundamental fairness and the absence of fundamental fairness.
So you've got a North Carolina corporation with a North Carolina CEO with a couple of entities, one the holding company, the other a significant investor. I mean, I don't see the full capital structure in front of us. But when you have a North Carolina corporation and you are more than just a stockholder, if you will, you are engaged, as the allegations seem to be, with regard to day-to-day decisions, particularly with regard to hiring and then firing a CEO. What is fundamentally unfair about bringing that person in North Carolina, particularly when, as I understand the employment contract, it talks about that it will be interpreted under North Carolina law and will that North Carolina law is the choice of law?
Sure. Well, first, we're not dealing with a North Carolina CEO, Mr. Chief Justice Newby. We're dealing with a CEO who is a resident of New Jersey and who, under the employment agreement, was to work principally from New Jersey. So we're dealing with an out-of-state resident who was to work in New Jersey.
Are you disputing that the company for which he was CEO is not a North Carolina corporation?
I'm not, Chief Justice, not disputing that, but there is a long-standing rule that officers and directors of corporations are not subject to personal jurisdiction in the states in which those companies operate, merely by virtue of the fact that those companies operate in that jurisdiction. They must independently engage in acts in that state in order to be subject to jurisdiction there. And that is actually a fundamental assumption that most all officers and directors undertake when they agree to serve on a corporate board or as an officer of a corporate company, whether it be for a company or even a nonprofit, right? They know that I am going to be subject to personal jurisdiction in places where I undertake activity and in jurisdictions with which I have contacts. But the contacts of the organizations and the companies with which I interact, they cannot be imputed to me simply because I'm affiliated with that company. And that proposition was stated by our Court of Appeals in Godwin v. Walls and has been quoted several times in other contexts, saying, again, we don't impute contact just because a company is headquartered in North Carolina doesn't mean the officers and directors of that company stand subject to jurisdiction in North Carolina by imputing the contacts. And here we're even further afield with Mr. Ellis, because Mr. Ellis, while the business court said he exercised partial control over Level 4 Inc., I think if we actually review the record and inspect Mr. Button's affidavit, we would not find factual support in the record for that assertion. What we see in Mr. Button's affidavit is a very ordinary investment relationship in which Mr. Button describes informing Mr. Ellis about the status of the investment. And while, yes, Mr. Ellis had involvement, according to Mr. Button, in the hiring and the firing of the CEO, to say that he engaged in control of the company is not consistent with the facts. But again, under longstanding law, under long-established law in North Carolina, and really in every state in the country, again, the contacts of an officer and director, the contacts of a company aren't attributed to an officer or director. That person, under specific jurisdiction rules, must have contacts with the jurisdiction personally. And that is just part of the specific jurisdiction analysis.
Mr. Church, when you emphasize the word personally, are you referring to are you asserting that the corporate officer, et cetera, has to have contacts with the forum separate and apart from his or her individual activities on behalf of the entity with which he's associated or she's associated?
No, Your Honor. The contacts can certainly be in the capacity, in that person's official capacity with the forum. So they don't have to be an individual. But here, when we're speaking,
so the answer, at least with respect to Mr. Ellis, in your view, hinges upon, what role did he play with respect to these particular entities as it related to the subject of this litigation?
well, I don't think that the question is what role did he play. The question is what were his
What did he do? Maybe would be a better way to put it.
and more specifically, what were his contacts with North Carolina in the course of what he did? And that's where we come up empty when we look at the record. What were his contacts with North Carolina?
Can you address the second part of that earlier question about the impact of the choice of law provision in the contract that is alleged to be the contract that's being interfered with? If the contract says that it'll be enforced in North Carolina, and the allegation is that he interfered with that contract, why wouldn't that be sufficient to bring him in jurisdiction here?
So the contract itself is being enforced in North Carolina. Mr. Button is suing Level 4 Inc. on the contract in North Carolina. But the proposition that one can use a choice of law clause in a contract to which a third party is not a party to pull that person into jurisdiction in a forum to which that person has no contacts, that violates the specific jurisdiction principles.
Well, it's not that he's a party to the contract, it's that he's allegedly interfering with it.
And I agree, Your Honor, that those are, Ms. Justice Earls, that those are the allegations that he's interfering with it. But the question is, what are his contacts with North Carolina? That is the specific jurisdiction question. What are his contacts with North Carolina? And so the fact that the contract with which he's accused of interfering has a consent to jurisdiction or venue or choice of law clause in some other jurisdiction, we open up a Pandora's box of jurisdictional principles if we start to say, well, you're subject to jurisdiction in any state where the contract specifies choice of law, forum, or venue. If you're accused of interfering with that contract, irrespective of whether you have contact with that state, that becomes a very problematic rule
Mr. Church, let me
Mr. Church.
let you go ahead, Justice Hudson.
I was just going to ask, the appellees point to allegations that Ellis had numerous contacts toward North Carolina, including negotiating Mr. Button's contract, negotiating the interest cap on the rate, discussing the company's performance on at least 15 occasions, and participating in Button's termination in North Carolina, as well as it being a North Carolina company. Is it your position that those things are not significant minimum contact?
Justice Hudson, the record does not support that almost any of those were North Carolina contacts. So the employment agreement negotiations occurred in Florida, New York, and New Jersey. There was no contact with North Carolina in the course of any of those negotiations. In addition, the contacts between the two regarding the business of Level 4 Inc., if you read the affidavits, there's actually only a single conversation described where Mr. Button was even physically present in North Carolina. The balance of them occurred when Mr. Ellis was in Florida and Mr. Button was in New Jersey. So we're really left with
Is it your position that physical presence is required for there to be minimum contacts with North Carolina?
if the two parties to the contacts, if neither party is present in North Carolina, then I don't see how there could be contact with North Carolina.
What about the company's presence in North Carolina? Is that irrelevant?
Well, it goes back again to the imputation of contacts. Are we going to impute the contacts of the company to its officers, directors? And in this case, again, Mr. Ellis is not an officer or director of Level 4 Inc. He's an agent of an investor of the owner. I mean, we are talking about many, many levels removed here from being an officer or director. And so that's the essential question. So we're really left with a telephone call. The question here is, can this telephone call in which Mr. Button was informed of his termination, can that suffice to subject Mr. Ellis to personal jurisdiction? And I'd submit this court's precedents say no. As recently as this court's decision in Muha v. Wagner, when this court observed that contact with a person is distinct from contact with a forum, right? Mr. Button was transiently present in North Carolina. And the difference, again, between Muha, which of course was held that there was no personal jurisdiction, and all of the cases Mr. Button cites, is that in those telephone calls where personal jurisdiction exists, those telephone calls themselves are tortious. Mr. Button
Let me ask you, as I understand the facts, and tell me if I'm missing this, that on the day of the meeting in Winston-Salem to talk about Mr. Button's status, that Mr. Button and Irish were physically in Winston-Salem and Mr. Ellis joined by telephone. Are you saying that that meeting didn't constitute a contact with North Carolina?
Justice Hudson, while it did constitute a contact with North Carolina, that contact was not sufficient standing alone or in combination with a couple other contacts to satisfy personal jurisdiction over Mr. Ellis.
And do you have authority for that?
The authority for that would be, well, the Court of Appeals decision in Miller versus Figali, which held that multiple phone calls into the jurisdiction were insufficient to satisfy personal jurisdiction over the defendant. There are instances where the courts have held, of course, yes, phone calls into the jurisdiction do not necessarily subject a defendant to personal jurisdiction here. And again,
do you have any cases that had phone calls to join a meeting in which people were physically present in the state? They're all part of the same company?
There's also, I believe, Mr. Button cited a Court of Appeals case, Bell v. Mosley, which was, I believe, an alienation of affection case where there were some phone calls between two participants who were at times during phone calls both present in North Carolina, but who were actually both out-of-state residents. And the Court of Appeals reversed the exercise of personal jurisdiction in that case, reasoning that those, again, a single phone call is insufficient basis to sustain jurisdiction. Where a phone call can give rise to specific jurisdiction is when that phone call itself is the basis of is itself tortious. If I call Mr. Russell from out of state and defraud him over the phone, that could be potentially give rise to jurisdiction. But here we're talking about an informational call. The tort has already happened, according to Mr. Button.
Well, let me back up to something you said about residents. In the case that you were referring to, you said that the two individuals were resident elsewhere. What do you contend is the residence of the company here?
The residence of the company, Level 4 Inc., is in North Carolina, but the two parties at issue in this appeal, Mr. Button, the plaintiff, and Mr. Ellis, the defendant, neither are North Carolina residents.
But you don't dispute that Level 4 is?
I don't dispute that Level 4 is, and Level 4 Inc. is subject to jurisdiction here on this claim.
Counsel, I would just point out that you're well into your rebuttal time or your
Thank you. Thank you, Chief Justice. I will make one point with respect to level 4 holdings before I reserve the remainder of my time. The business court relied on the consent to jurisdiction clauses in contracts for which it had dismissed the claims in order to exercise jurisdiction over level 4 holdings for the civil conspiracy claim. That's a big problem that this court needs to really hone in on. Contracts specify the reach of consent to jurisdiction, and if we start interpreting contractual clauses that say I consent to jurisdiction for specific claims, if we start to say, well, sorry, we're not going to interpret the language of the parties' agreement to reach what they agreed it would reach, we will instead interpret it for all times and all claims. We're going to really disrupt the way businesses operate and the way that the ordered expectations of parties to contracts under that regard.
So your argument then is, in effect, if I'm understanding you correctly, that the consent to jurisdiction provisions in a number of these contracts are simply totally irrelevant and should not be considered in determining whether your clients have sufficient contacts with the state?
They are relevant to the contracts that are at issue where they're.
So your argument is, in the absence of a breach of contract action predicated specifically upon an alleged breach of the contract that contains the form selection clause, that they can't be considered in any other way in a minimum contacts analysis?
That would be consistent with the principles of specific jurisdiction, which asks.
Is that your argument?
I would say never, but the concepts of specific jurisdiction say you must evaluate the relationship of the contacts to the claim and the defendant. Now,
go ahead.
I'm sorry. If you've got any more questions, Justice Urban, I'll reserve the remainder of my time.
Thank you, counsel. We'll hear from the appellee.
Good morning, and may it please the court, Mr. Chief Justice and Associate Justices. My name is Steve Russell of the Guilford County Bar. My colleagues, Alan Duncan and Tyler Nullmeyer, are here with me off camera. We represent Jamie Button, who is the plaintiff here, the plaintiff appellee and the cross appellant. And Mr. Button is joining us on the YouTube stream. I will reserve 5 minutes for rebuttal on our cross appeal. And in my argument now, I will first address the jurisdictional issues before moving to the cross appeal. This case is about a series of employment-related agreements that were entered into at the start of Mr. Button's employment as CEO of Level 4 Inc., and a common scheme to harm the severance, equity, and other rights that Mr. Button had under those interconnected agreements. There are 4 provisions that are particularly important to this appeal. First, the agreements collectively gave Mr. Button the right, in certain circumstances, to acquire a majority interest, 51% of Level 4 Inc. If he did that, he would supplant Level 4 Holdings as the majority owner of the company. The circumstances when that could happen were if he served a sufficient time under the agreements, or if he was terminated without cause. Second, the employment agreements gave Mr. Button the right to a substantial amount of severance for a without cause termination. Third, the employment agreements defined for cause. That definition was then used in all of the agreements. And fourth, the agreements provided for venue and jurisdiction in North Carolina for related disputes. Now, the key event, it's already been discussed, occurred in March 2019 when Mr. Button was in the Winston-Salem office for regular management meetings at the company's main office here in North Carolina. And it's well established in the record that it was a very regular practice, part of the management of the company, that Mr. Button traveled and worked very regularly in North Carolina. At that meeting, he was terminated as CEO, alleged in this case as a result of this common scheme, and it was classified as a for-cause termination. Of course, when Mr. Button then asked for the cause, the defendants would not tell him. Because it was a for-cause termination, Mr. Button lost that right to acquire a majority interest in Level 4 Inc. and lost his right to over $400,000 in severance. The first issue is the business court's personal jurisdiction rulings, and the standard of review is whether the ruling is supported by competent evidence in the record. As to level 4 holdings, the business court's ruling should be affirmed, and there is a direct path to affirmance, and it is those consent to jurisdiction provisions between level 4 holdings and Mr. Button. An example is the option agreement. This is at page 74 of the record, section 4.8b. It says, quote, any judicial proceeding brought by any party with respect to the subject matter of this agreement must be brought in the appropriate court of competent jurisdiction where the corporation's principal office is located. Now, even though this was a contract with level 4 holdings, it defined the corporation as level 4 Inc. And there's no dispute that this jurisdiction and forum selection clause selected North Carolina. Mr. Button has sued level 4 holdings for breach of fiduciary duty, civil conspiracy, tortious interference with contract, all arising from this scheme to deprive him of his equity rights, as alleged among other places in paragraphs 219 and 221 of the complaint. Those equity interests are his rights under this option agreement, as well as the warrant agreement with level 4 Inc. And he's asserted the declaratory judgment claim, asking the court to determine the parties' respective rights under various agreements. These are squarely claims, quote, with respect to the subject matter of the option agreement and the other contracts. The clause does not say it must be a breach of contract claim. And this raises the central irony in level 4 holdings' position. Under the parties' contracts, Mr. Button could only bring his case against level 4 holdings in North Carolina. Of course, jurisdiction is appropriate in the state that the parties have determined is the exclusive forum for their disputes. And in the Burger King case from the U.S. Supreme Court and elsewhere, it's clear that enforcing these kind of provisions fully comports with due process. Now, the business court did not consider those provisions as dispositive, but rather a factor in the minimum context analysis. Now, we would submit as an alternative basis to affirm they are indeed dispositive. Regardless, they certainly are competent evidence. Appellants have primarily attacked the business court's method of applying the long-arm statute, which condensed the two-step process into a unitary due process analysis. But that's essentially the same approach this court took in Beam versus Grax, where the focus was on traditional due process issues instead of a formalistic statutory analysis. It's well established that the long-arm statute is construed expansively up to the limits of due process. And this court in Dillon v. Numismatic Funding and other cases has construed NC General Statute 1-75.41D as capturing that notion of jurisdiction up to the limits of due process. To turn then to the minimum contacts analysis. Level 4 holdings did not submit an affidavit, so the allegations in the complaint and in Mr. Button's affidavit stand unrebutted as to that part. And I think a key point from the business court, and one that rings true, is that Level 4 holdings should not have been surprised to be held into a North Carolina court for a dispute with Mr. Button, when that is exactly what it agreed to do, regardless of whether you are enforcing the jurisdiction clause in and of itself or analyzing minimum contacts. The record, the allegations and evidence also shows that Level 4 Holdings was fully involved in negotiating all of the agreements to hire Mr. Button as the CEO of this North Carolina entity, among other places in paragraph 13 of the complaint and paragraph 6 of Mr. Button's affidavit. And Level 4 Holdings actively involved itself in Level 4 Inc.'s North Carolina operations. A prime example of that can be found in the employment agreement, which provides, and this is an agreement between Level 4 Inc. and Mr. Button, but it provides that Level 4 Holdings maintains the decision-making authority over whether certain offices of the company would be moved from North Carolina to another state. Level 4 Holdings was also present in North Carolina, including via its manager, Miss Irish, when Mr. Button was terminated here. These consistent contacts by Level 4 Holdings, as it conducted its business, were directed at North Carolina and sufficient to confer personal jurisdiction in this case. The business court's minimum contacts analysis about Mr. Ellis is also supported by competent evidence. Unlike level 4 holdings, Mr. Ellis did submit an affidavit, but it does not rebut much of what's alleged in the complaint and what's also established in Mr. Button's affidavit. Of course, the business court, when there are dueling affidavits, can weigh those as it makes a jurisdictional determination. What the record shows is that Mr. Ellis was intimately involved in the North Carolina affairs of this North Carolina corporation at the start of Mr. Button's time with the company, during the course of employment, and perhaps most notably at the end when the termination occurred. At each turn of the story, Mr. Ellis keeps popping up again and again. He negotiated the agreements related to the ownership and operations of Level 4 Inc. and Mr. Button's hiring. Again, that's paragraph 13 of the complaint, paragraph 6 of Mr. Button's affidavit. Those agreements that Mr. Ellis participated in negotiating included these North Carolina jurisdiction clauses. Mr. Ellis was regularly involved in the management of Level 4 Inc. during Mr. Button's employment. Mr. Button was required to regularly report to Ellis and Penta. There were a series of approvals that Ellis and Penta made of business plans of Level 4 Inc. As further discussed in Mr. Button's affidavit, there was at least one other time when Mr. Button was in North Carolina, engaged in a phone call seeking addressing management issues with Mr. Ellis. Mr. Ellis reviewed business plans that included how operations based in North Carolina would function. He reviewed financial reports prepared by Level 4 Inc.'s Winston-Salem office. And this one is perhaps the most telling, perhaps not the most significant, but the most telling, that Ellis directed Level 4 Inc.'s employees in the Winston-Salem office to receive free flu shots. That's a good example of the level of control and involvement that was present here. And of course, at the end of Mr. Button's employment, Mr. Ellis reached into the state by telephone in that meeting in Winston-Salem where the termination occurred. There's been a suggestion this morning that the termination occurred somehow before that meeting. Well, that's not what's alleged. What's alleged at paragraph 118 without rebuttal is that Mr. Button was told he was being immediately terminated for cause. And at 124, to rebut the notion he had already been terminated, Ms. Irish asked Mr. Button if he would instead resign. And in defendant's appellant's brief at 17, as they are describing this meeting, they describe it as having the practical effect was to end an employment relationship that was based in New Jersey where Mr. Button lived. We obviously disagree about the based in New Jersey part, but it's that practical effect of the meeting to terminate the employment that's the key admission. The business court's characterization of this evidence as illustrating Ellis's participation and partial control of Level 4 Inc. was exactly right. And I would refer to the court to the Better Business Forms versus Davis case from the Court of Appeals, which involved out-of-state negotiations for the ownership and operations of an in-state entity, and their jurisdiction was found to be sufficient. Additionally, Mr. Ellis's affidavit does establish that he has traveled to North Carolina in connection with his role with Penta Fund, which is the same role, of course, that gave rise to his contacts with North Carolina here. The business court's analysis of all of these contacts was consistent with Beam versus Grax, and what the court's being asked to do here by the defendants is essentially to repeat the analysis that was rejected in that case. There, because Grax's contacts with North Carolina related to Beam and that partnership agreement, and the case was concerned with his conduct under the partnership agreement, it simply cannot be said that subjecting Grax to suit in North Carolina would trigger due process concerns. Contrary to Beam, Ellis argues that his contacts in North Carolina with the North Carolina Corporation and its CEO before the termination should be disregarded, I suppose because they did not give rise to the claim, but that, again, that's precisely the approach that Beam rejected. Each of Ellis's contacts were in his status with Penta Fund as this investment committee member and showing this really rigorous oversight of Level 4 Inc. All the claims against Mr. Ellis are based directly on that status.
So it seems like your colleague was arguing that there's this general principle that officers and directors of companies can't be hauled into the jurisdiction or brought into the jurisdiction of the company for acts that they did as officers and directors. One, do you agree that general principle is true? And two, were it to be true, what would cause this case to be exceptional or deviate from that general principle?
As a very abstract principle, I suppose I wouldn't necessarily disagree with it, but these are evidence and record-based determinations that we make on personal jurisdiction. Here, Mr. Ellis was not an officer or director of Level 4 Inc. He was an investment committee member of Pentafund. Mr. Button was the CEO of Level 4 Inc. And the record shows that as CEO, he was regularly working in North Carolina, and even when not physically here, when he would travel to other company locations in other states, he was regularly directing the core company operations that were located in North Carolina. So when with Mr. Ellis, you have his regular involvement in the hiring of a CEO of a North Carolina company to that role, and when you have the regular actions that Mr. Ellis took, essentially directing Mr. Button in his work as CEO of the North Carolina company and directing the operations in North Carolina, it would take it from a very abstract principle to concrete facts that are certainly competent evidence for the business court's decision here.
So to put your view of the relevant test another way, the mere fact that someone is an officer or director of a corporation or other entity by itself, standing alone, isn't enough, but it is permissible for a court to exert jurisdiction over such a person if he or she does something that purposely avails himself or herself of the right to do business in a particular area as part of their official activities on behalf of the entity.
Yes, Justice Ervin, I think that's a good characterization of how you would move from that very general high-level principle to the actual record that's before the court and that was before the business court. Mr. Ellis also places much weight on physical presence, physical location in North Carolina. As this court held in Tom Togg's, lack of action by a defendant in a jurisdiction is not now fatal to the exercise of long-arm jurisdiction. That is the modern trend in the modern analysis of personal jurisdiction. And certainly, as the last 18 months have shown us all, through modern technology and our new business practices, we can easily be anywhere when we are transacting important North Carolina business. The final consideration on jurisdiction is really highlighted by a passage in defendant's brief and something that counsel said this morning, and it's the importance of North Carolina's interest in hearing the case. It said in defendant's brief that when that meeting in Winston-Salem occurred, Mr. Button was transiently present in North Carolina. This is a really dismissive characterization of the record here because the unrebutted evidence is that Mr. Button regularly came to North Carolina as part of his duties of this North Carolina corporation with its main office here, employed lots of North Carolinians. He was in North Carolina for regular business meetings when the termination occurred, and his employment and equity rights were governed by contracts with North Carolina jurisdiction clauses. If this is going to be a state where people want to come on a regular basis to conduct their business in a nationwide economy, we want companies to base their major operations here, and it's hard to think of a reason why North Carolina's interest would not be exceedingly high. When those individuals and companies do come here permanently or regularly, their presence here should be fully considered by this court when they've been harmed in this state and are seeking redress for that harm. In sum, the business court's personal jurisdiction ruling should be affirmed. I'll turn now to the cross appeal. Mr. Button has cross appealed from the partial dismissal of two claims. First is the declaratory judgment claim against Level 4 Holdings. It was dismissed on non-justiciability grounds. That claim remains against Level 4 Inc. under others of these interlocking contracts. In the tortious interference with contract claim against Level 4 Holdings, against Mr. Ellis, and against Pentafund, that was dismissed under Rule 12b-6, but it remains against defendant Rebecca Irish, who's not subject to any of the claims on not part of the appeal here. These are reviewed de novo, and the appealability of these claims has been very thoroughly briefed before the court. I'm not going to focus on those, and instead we'll turn to the merits of the arguments. First, the declaratory judgment claim. This really is an important claim in this case, particularly the declaratory judgment as to the option agreement, because it's that option agreement with Level 4 Holdings and the warrant agreement with Level 4 Inc. that collectively give Mr. Button that right to acquire a majority interest and supplant Level 4 Holdings as the majority owner of the company. Only by pleading that claim now could we establish in this proceeding Mr. Button's entitlement to the full scope of that compensation that he agreed to, the equity rights.
If I understand your colleague's argument, Mr. Russell, he's saying in effect that he doesn't deny that at some point you would be entitled on behalf of Mr. Button to bring a declaratory judgment action. He just says it is in essence premature because you haven't said that Mr. Button actually intends to exercise the rights that are the subject of these claims. I think that's his argument. If it's not, you can correct me and he can correct me on his additional time. If that's the case, and given that we've got decisions in this context that say that you can't, I think the expression from the late lower case is you can't get an advisory opinion and put it on ice for later use or something to that effect. He says you're doing that. Why is he not right?
I do think that, as I understand it, is a fair characterization of their argument. And as best I can understand, that's the same principle the business court applied here. I think that's not right in the first place because I don't believe a pleading rule like that exists under North Carolina law. There is no special pleading requirement under the Declaratory Judgment Act or Rule 9 if you're seeking a declaratory judgment about an option contract.
You do have to plead sufficient facts to show the existence of an actual controversy, don't you?
That's exactly right. That is the test.
And at least my understanding of the business court's position and the position that's espoused by your colleague is that you don't have an actual controversy in the absence of an expression of intent on the part of Mr. Button to exercise the disputed rights. Why would someone who thought that be wrong?
That would be wrong because it's, I believe, based on a false premise that the business court drew from the Sharp case from this court and the Colton case from the Court of Appeals. Those two cases really looked at circumstances when there's not a genuine controversy, because in Sharp, it was essentially the action was brought prematurely. There was these promissory notes with a 10% interest rate provision. The interest rate would go to zero if a party competed with the newspaper. But there had been no change in the facts on the ground of those parties' relationships. It was just purely theoretical. In Colton, we have a declaratory judgment claim that's brought 18 months after a stock transfer occurred with no challenge in the interim. And in that circumstance, you have a stale claim. What's different here is the termination of Mr. Button without cause. I say that was purportedly classified as for cause, which is the underlying issue in all of these claims, immediately deprived him of the right to exercise the option under the option contract's plain language. There has been that change now in the parties' relationship and their contract rights. That's why this is not theoretical. It's not a change in relationship that could occur down the road. It's not stale, something that occurred long in the past. Mr. Button brought this case about 10 weeks after he was terminated, as opposed to 18 months in that Colton case.
I have a slightly, and I don't mean to interrupt if you hadn't finished your answer to Justice Irvin's question, but I have a slightly different question about whether the declaratory judgment action against Level 4 Inc. would control in the claims against the holding company.
Justice Earls, I wish I could say with confidence that it did, but that would require us to be presuming the outcome of some kind of claim preclusion analysis down the road. The fact is, right now, Level 4 Holdings is a party, and even under the business court's order, will remain a party to multiple claims that go to these exact same issues. But the only way now to ensure the completeness of Mr. Button's relief under the terms of his interlocking employment agreements is to obtain the declaratory judgment now, as opposed to waiting for some further decision and then assuming how that decision would be played out with other parties in some subsequent case. The last point I'll make, and I believe, Justice Ervin, this goes back to your point, is that option contracts are really ill-suited for this notion of a special pleading rule. Because part of the value of an option is that you can choose to exercise it within the time allowed or not. You, as the option holder, have that as the full scope of your rights. That gives it value. A pleading rule would, in essence, require the option holder to diminish their rights by at least expressing this interest or this intent to exercise the option in order to seek clarification of whether they have the right at all. Otherwise,
I mean, why would that be the case? If you just said it, if you were to take what I took to be the business court's invitation to go back and simply replead and say, defendant Mr. Button intends to exercise, but does not irrevocably commit to exercising the rights. How does that harm you with respect to the option agreement?
Well, first, and that in and of itself means Mr. Button has to take some action that at least in some way narrows or limits the scope of his rights under the option. But by expressing that intent now, it would require him to make a business decision, or at least represent to the court that he's made a business decision before he's required to do so under the contracts. And otherwise, that would just be a gratuitous or futile allegation, because it wouldn't in and of itself change the parties' legal relationship. It wouldn't presumably in and of itself exercise the option. And unless Rule 11 was applied in some novel way to that kind of allegation, it could later be disregarded. I think the way you framed the question, which would include this caveat about not irrevocably stating this, just goes to illustrate how ultimately it would be a gratuitous kind of allegation. I know I'm getting close to my 5 minutes, but I will try right now and reserve a few minutes to address the tortious interference with contract claim. What's been alleged is a scheme to benefit Penta and its investors, including Mr. Ellis, by charging higher interest on the loans made to Level 4 Inc. above the 2.5% interest rate cap that was negotiated into Mr. Button's employment agreement. That part of the scheme is set out at paragraphs 98 through 113 of the complaint. When Mr. Button refused to agree to a higher interest rate, he was terminated for cause by defendant's actions, and that's at paragraphs 114 through 136 of the complaint. The business court held that the claim should be dismissed because it did not sufficiently allege legal malice, which is the fourth element of a tortious interference claim, whether the defendant acted without justification. These defendants have been viewed as non-outsiders, which traditionally would apply to someone like an officer or director or a shareholder of a company. And it presumes that they're acting in the company's best interest, here acting in Level 4 Inc.'s best interest. But that can be rebutted. It's a rebuttable presumption. And it's overcome if the non-outsider is not acting in the company's best interests. For example, if they're acting in their own interests. I would direct the court or refer the court to paragraphs 200 and 201 of the complaint, which address this element in particular. In Embry Construction versus Raftcore, this court discussed the kind of allegations needed to overcome the rebuttable presumption. And it set what is really the traditional pleading standard in North Carolina. The presumption's overcome when the complaint alleges facts demonstrating that the defendant's actions were not prompted by legitimate business purposes, and the court reinforced that claims for tortious interference, like others, are reviewed under a notice pleading standard that looks to whether the complaint gives notice of the events giving rise to the claim. The business court considered these allegations of malice to be merely conclusory, but when the full complaint's considered under the correct standard, we would suggest to the court that it sufficiently alleges these defendants did not act in Level 4 Inc.'s best interest, because all of their actions were directed to the effort to raise the interest rate on the promissory notes to Level 4 Inc. from 2.5% up to 8 or 12% for past funding and future funding. Quintupling or quadrupling the interest rate on over $9 million of debt would certainly not benefit Level 4 Inc., but would benefit its lender, PentaFund, and PentaFund's investors like Mr. Ellis. And the other elements of the scheme as alleged, including the termination, occurred when Mr. Button continually resisted the efforts to raise Level 4 Inc.'s interest in that way. In their briefing, the defendants offer only one explanation for the interference, that they claimed a legitimate business purpose in saying that PentaFund's loans to Level 4 Inc. were supported by executed promissory notes. But the complaint already addressed this issue. At paragraph 112, Mr. Button told defendants that he was prepared to sign promissory notes for Level 4 Inc. that were modified to include the contractually agreed upon rate. So if that was the legitimate business concern, it's already been addressed in the complaint that they could have achieved that as Mr. Button offered. What this argument by defendants really is an acknowledgement that they were acting on PentaFund's behalf. They've admitted they wanted promissory notes that secured for PentaFund interest above 2.5%. And if they were acting in PentaFund's interest, in the interest of PentaFund's investors, then by definition, they were not acting in Level 4 Inc.'s best interest. That satisfies the fourth element. So as with the declaratory judgment claim, we respectfully submit that application of the appropriate pleading standard to the tortious interference claim requires reversal of the business court's order. And I will reserve the remainder of my time. Thank you.
Thank you, counsel. We'll hear from we'll hear rebuttal.
Counsel, you're muted.
Let me make sure the court can hear me. Okay. Begin my time by clarifying, Chief Justice Newby, you posed the question to my colleague about whether individuals can be hauled into North Carolina for their acts as officers or directors of a corporation, whether somehow they were exempt if they're out for in their official capacities. And I think in a follow-up, Justice Irvin summarized correctly the proposition, which is that the mere fact that someone is an officer or director of a corporation is not sufficient to subject that person to jurisdiction in a forum. That individual must specifically have contacts with the forum independent of the corporation or the entity for which that person serves. And so this constant appeal to, well, Level 4 Inc. is a North Carolina corporation, we must avoid focusing on that and instead focus on the contacts of the defendant and the relationship of the defendant's claims to the forum in order to assess specific jurisdiction. And that is the test. And so what's really at issue here in this case is hollowing out the test of specific jurisdiction. So my colleague says, the business court applied this court's decision in Beam Limited Partnership versus Grax Consulting. And I would argue the business court did not apply Beam versus Grax at all. In fact, the business court said that the decision in Beam stood for the proposition that we need not narrowly examine the relatedness of the contacts between the cause of action and the forum. And that is not what Beam stands for. And in fact, that's not what the specific jurisdiction analysis stands for at all. We must, as a matter of specific jurisdiction, analyze the relatedness of the contacts to the forum, and the analysis in which the business court analyzed threatens to hollow out the specific jurisdiction analysis. In much the same way, the proposal that we take contractual consent to jurisdiction provisions and apply them to tort claims that relate to different allegations and different contracts. I mean, this is a sleight of hand. That hollows out specific jurisdiction. It makes it easier to sue foreign defendants in North Carolina. It makes it more costly, more difficult to do business in North Carolina. I find some irony in my colleague's assertion about North Carolina's interest in being a forum for this dispute. North Carolina is the forum for this dispute. This case continues. Mr. Button is suing Level 4 Inc., PentaFund, and Rebecca Irish, the sole director of Level 4 Inc. in North Carolina. That case continues irrespective of the outcome of this appeal. North Carolina's interest is being considered and perpetuated in this case. What North Carolina does not have an interest in is yanking in the agent of an investor of the owner of the company with which Mr. Button had a contract. This is not the situation where North Carolina's interest is so compelling that we need to hollow out specific jurisdiction and stop asking the questions about the relatedness of contacts to the forum. And in much the same way with Level 4 Holdings and these contracts. This is, Mr. Buttons is getting his day in court in North Carolina. His rights, he will have the opportunity to have his rights vindicated here. But the reach he is asking for this court to hollow out the specific jurisdiction rules is going to result ultimately in rules that surprise.
Well, to be clear, Mr. Church, to the extent if you were to prevail with respect to the jurisdictional issue, Mr. Button would not get his day in court in North Carolina with respect to any claim that he might have against Mr. Ellis, right?
He would have to go to.
If he wished to pursue those claims, he would have to go to some other jurisdiction.
That's correct. He would need to pursue them in a jurisdiction that had personal jurisdiction over Mr. Ellis. Now, with respect to the cross appeal, my colleague skipped over the notion about appealability, which I would argue is the most important thing that the court needs to consider here. My opponent has attempted to cross appeal a dismissal without prejudice of two claims against him. And there is no precedent for this court considering an appeal as of right under the substantial right test of a cross appeal. And ironically, he observes that there's no case analyzing this under the substantial right. And I would argue again, because a dismissal without prejudice simply cannot affect a substantial right. And nor is there any instance where this court has granted a writ to entertain a dismissal without prejudice. And so there's simply no basis to start that in this case. But as to the merits of those claims, with respect to the Declaratory Judgment Act, there is this incredible reluctance to commit to whether Mr. Button intends to exercise any rights under those agreements. And I noted in his brief, I think he neatly explained why. On pages 25 and 26 of his cross appeal brief, Mr. Button acknowledged that he would have to raise, and I quote, millions of dollars, unquote, to exercise his rights, and that doing so would be, quote, nearly impossible, unquote. And those are his words, nearly impossible. So we understand his reluctance to allege that he intends to exercise those rights. He doesn't want to have to sit down later in a deposition and acknowledge that he was just trying to get this in front of a court for leverage for some other reason. And again, that is not, the business court absolutely correctly observed that it is not the purpose of the court to issue advisory opinions. With respect to tortious interference, the business court likewise correctly observed that the allegations of tortious interference against the defendants were the quintessential generalized allegations of malice. And again, let's note in this case, the entities that are alleged to have maliciously interfered with the companies, they're all in the ownership structure. So he says Pentafund tried to raise the rate of interest on Level 4 Inc. Pentafund owns Level 4 Inc. There's no allegation that real money was being lost to anyone. And so the business court can easily see there's justification evident on the face of the complaint. And this court held most recently in adopting the business court's decision in Wells Fargo Insurance Services versus Link, that in order to survive dismissal, a complaint alleging tortious interference must admit of no motive for interference other than malice. And it's evident on the face of this complaint that there are multiple motives for interference, putative interference other than malice, and therefore the business court correctly entered dismissal. This is not an occasion on which the court should grant an extraordinary writ or otherwise entertain appeal. Thank you.
Thank you, counsel. Sir, rebuttal.
Thank you, Mr. Chief Justice. And just very briefly, I want to touch on this notion of a without prejudice dismissal. And the implication seems to be, well, just go back to the business court and amend your complaint, assert this new allegation that may or may not be a requirement to plead a declaratory judgment claim in North Carolina. That's the question that this appeal, the cross appeal, raises, and that this court, I believe, is well situated to answer here. That it is just the fact-intensive case-by-case analysis. There's not a blanket pleading rule that you need to establish that your declaratory judgment claim is neither theoretical and premature on the one hand or stale on the other hand. Likewise, the appeal now is appropriate to preserve and allow Mr. Button to obtain redress for the full set of his rights, including that ability to become the majority owner of the company and supplant Level 4 Holdings, which requires the analysis of the full set of claims in light of the interlocking nature of the agreements as the parties structured them. Thank you very much for your time today.
Thank you to everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.